Welcome, and thank you for joining us. Please note that this AI-generated podcast is intended solely for general learning and educational purposes. While we strive to ensure accuracy, the AI may occasionally produce errors or incomplete information. We strongly encourage you to consult qualified professionals and conduct your own due diligence before making any legal, financial, or business decisions based on the content presented here. Also, if you find this content valuable, we kindly request you to like the video, subscribe to the channel, and activate the notification bell to receive updates on future episodes. Let's begin.
Okay, let's dive in. We're looking at a really interesting legal fight today. And it's not about some, high-tech gadget. It's about weed killer.
Yeah, specifically a legal battle that hinges on, a colored dye. Just a coloring agent in an agricultural spray.
Seems almost mundane, but it sparked this major patent dispute. We're talking Crystal Crop Protection Limited versus Safex Chemicals, India Limited, and others, playing out in the High Court of Delhi.
Right. Crystal Crop holds the patent, and they're saying Safex infringed it.
But here's the twist, and it's a good one. The Safex products, the ones accused of infringing, they don't actually contain this dye that Crystal Crop specifically included in their patent claims.
Exactly. So the big question, the puzzle we're unpacking is, can you take most of a patented invention, leave out one specific bit that was claimed, and just walk away saying no infringement, even if that bit seems, maybe minor?
So that's our mission for this deep dive. We want to get into the weeds of this recent interim court ruling. What were the arguments? What did the court decide for now? And crucially, why?
We're really trying to understand the legal reasoning, the chess moves behind this initial decision.
Okay, let's start with the basics. Crystal Crop's patent, number 417213. What's the invention supposed to be?
So the patent is for a weedicidal formulation. The core, you could say, is this specific blend of two herbicides, clodinafop and metribuzin.
Right.
And it's in a very specific ratio, 1 to 2.2. So 9% clodinafop, 20% metribuzin in a wettable powder. But the patent also lists other things, surfactants, safeners, and crucially, this dyeing agent or pigment.
And Crystal Crop sells this as ACM9.
Correct. Now, the defendants, Safex, and the others, they sell products like Racer, Trophy, Jody No. 1.
Okay.
And tests confirm their products do have that same core herbicide mix. Clodifop, 9%, metribuzin, 20%, that specific ratio. But, and this is the whole case, really no dyeing agent.
No dye.
Yeah.
Now, the timeline here adds another layer, doesn't it? Crystal Crop filed for the patent way back, 2010, 2011.
That's right. But Safex, the defendants, they actually started making and selling their product, the one without the dye, back in June 2020. They got the official registration they needed under the Insecticides Act in May 2020. And here's the kicker. Crystal Crop's patent wasn't actually granted until January 2023.
Wow. So Safex was already on the market legally with their version for more than 2 years before Crystal Crop even got the patent finalized.
Precisely. That timing is definitely relevant context. Crystal Crop then says they found Safex's product in January 2024 and filed the lawsuit asking for an interim injunction, basically, asking the court to stop Safex's sales immediately in March 2024.
And the court heard arguments back and forth for a while.
Yeah, over several months leading up to this judgment from Justice Amit Bansal on May 7th, 2025.
And let's just be super clear. This ruling we're talking about, it's only about that request for a temporary stop order, the interim injunction.
Absolutely. It's not the final word on infringement, and it's definitely not the final word on whether Crystal Crop's patent is even valid in the first place. Safex is challenging that, too, in a counterclaim.
Right, so this is just round one. The main fight is still down the road.
Exactly. Think of it like preliminary motions.
Okay, so back to the core issue. Is that dye essential? Crystal Crop argued, look, our real invention, the genius part, is that specific 1 to 2.2 ratio of the herbicides. That's the core. They painted the dye as just sort of an optional extra, an adjuvant or excipient, something that helps but isn't fundamental.
But Safex took the complete opposite view. They argued, no, the dye is essential. It's part of what makes the invention novel according to your own patent.
Right.
And since our product doesn't have that essential bit, they argued we haven't infringed. Simple as that.
Let's unpack Crystal Crop's side first. Why did they say the dye wasn't essential?
Well, their main points were, first, that the Patent Office, when granting the patent, recognized the inventive step primarily in that specific herbicide ratio.
Right.
Second, They pointed to language in their own patent description, suggesting the dye was just there to help farmers see where they'd sprayed. A visual aid, not core to the weed-killing function.
And they proved Safex had the core herbicide ratio.
Yes, they had lab reports showing that Safex's products contain that 1 to 2.2 ratio. They also, interestingly, pointed out that Safex themselves, in some of their regulatory filings, had referred to dyes generally as excipients, sort of using Safex's own language potentially against them.
So Crystal Crop's position was basically, they copy the heart of our invention. Leaving out this minor visual aid shouldn't get them off the hook.
Exactly. They invoked legal ideas like immaterial variation and the pith and marrow test.
Right, the essence of the invention idea.
Yeah, basically asking if the core inventive concept was taken, even with small changes. They cited other cases where courts said leaving out something non-essential didn't avoid infringement. They were trying to frame the dye as one of those non-essential bits.
Okay, makes sense. Now, how did Safex push back against that?
Their first point was the most direct. Our product doesn't have the dye. Full stop. The claim requires a dye. Our product doesn't have it. Therefore, no literal infringement.
Clear enough. But they didn't stop there, right? They used Crystal Crop's own patent document.
Oh, absolutely. This was a major part of their argument. They pointed directly to Crystal Crop's complete specification, the main patent document where Crystal Crop itself described the dye's inclusion as, quote, essential for visual identification.
Whoa. Essential? That word seems pretty definitive and kind of undermines the optional extra argument.
It certainly seems to, and Safex built on that. They argued the dye wasn't just for farmers seeing coverage. They claimed it served a technical purpose too, ensuring the powder formulation was visually uniform.
Why does that matter? Uniformity.
Because if the powder isn't mixed evenly, when the farmer adds water and sprays, some areas might get too much active ingredient, potentially harming the crop itself. That's called phytotoxicity. So Safex argued the dye helped ensure homogeneity, reducing that risk. It wasn't just cosmetic, it related to product quality and safe application.
Okay. That adds a technical dimension.
They also highlighted that Crystal Crop, in all the examples provided in their patent, always included the dye. There were no examples of a dye-free composition, suggesting it was, integral to what they actually invented and described.
And then they brought up this prosecution history estoppel idea?
Yeah.
Sounds important.
Very important. It's a really powerful concept in patent law. Basically, it stops you from contradicting yourself. If you told the patent office, my invention is special because it has feature X, to convince them to grant the patent. You can't later sue someone for making a product without feature X and argue, oh, feature X wasn't really important after all.
So you're stopped, legally blocked from changing your tune later.
Precisely. Safex presented evidence showing that during the patent application process, Crystal Crop had amended its claims and made arguments to the examiner and also fought off challenges from others by specifically pointing to the presence of the dye as a key distinguishing feature of their invention compared to what already existed, the prior art.
So they used the dye to get the patent, then wanted to argue it wasn't essential for infringement.
That was Safex's argument, yes. They said Crystal Crop couldn't approbate and reprobate, take one position to get the patent and the opposite position to enforce it.
They really hammered on Crystal Crop's past statements and actions.
They did. And alongside this, they also argued the whole patent wasn't valid anyway, claiming the ratio was already known, and it was just an obvious mix. But again, the court parked the validity question for the main trial.
Okay, so we have these clashing narratives. Dye is optional versus dye is essential, and you're stopped from saying otherwise. How did Justice Bansal navigate this? Especially since Safex's product didn't literally match every element.
Right. Since there wasn't literal infringement, the dye was missing, the court had to shift gears and look at the Doctrine of Equivalents.
Which is designed to catch copyists who make minor tweaks.
Exactly. It asks if the accused product does essentially the same thing, in essentially the same way, to achieve essentially the same result as the patented invention. The court used a well-known framework, a three-part test from a UK case, Actavis v. Eli Lilly.
And the first question of that test was key here.
It was central. That first question asks, does the variant Safex's product without the dye achieve substantially the same result and substantially the same way as the invention? But crucially, it adds, as the invention, i.e. the inventive concept revealed by the patent.
So first you have to figure out what the core inventive concept actually is, according to the patent itself.
Precisely. The court couldn't just guess. It had to go back to Crystal Crop's own patent document, just like Safex argued. The court needed to understand what problem the inventor claimed to solve and how they claimed to solve it.
What did the patent document reveal about this inventive concept?
The judge looked closely at the background section. It specifically mentioned a problem with prior art herbicides, difficulty in visually assessing their application and effect.
So right there, the patent acknowledges a visual assessment problem.
Yes. And then, in the objects of the invention section, one stated goal was explicitly to provide a composition whose application and effect on the weeds could be directly and visually assessed.
Okay, the link is getting pretty strong. Problem. Can't see it work. Objective. Make it so you can see it work.
Exactly. And then the detailed description section explained how, by using a suitable dye for this visual assessment purpose, helping farmers, even mentioning illiterate farmers, and highlighting the dye's unique dyeing property, the court saw a very clear narrative within the patent itself.
And where did the dye feature in the actual claims, the legally binding part?
This was also critical. The court noted the dye wasn't just mentioned in the description. It was included in both independent claims, the claim for the product composition itself, and the claim for the method of making it.
The main claims.
The main claims. The court cited patent office guidelines and case law basically saying independent claims must define the essential features needed to solve the technical problem the invention addresses.
So piecing that all together, the problem statement, the objective, the description, the inclusion in main claims, what was the court's initial take?
The court's prima facie conclusion, its view, based on the evidence at this stage, was that the dye could not be seen as non-essential.
Couldn't be.
No, because the patent itself presented it as serving a specific purpose, visual assessment, addressing a stated prior art problem, achieving a specific objective, and it was explicitly claimed as part of the invention's core structure. The court essentially said, you're bound by how you defined your own invention.
And did the prosecution history estoppel argument land with the court?
It did. The court looked at the history, saw how Crystal Crop had moved the dye into the independent claims during prosecution, and found evidence where they had indeed argued the dye's presence distinguished their invention from prior art to get the patent granted.
So arguing it was key then, but optional now.
The court found that wasn't permissible. Applying the estoppel principle, citing relevant cases, the judge stated that Crystal Crop couldn't approbate and reprobate. Having used the dye's presence to secure the patent, they couldn't now pivot and claim it was non-essential just to make an infringement case stick against someone who omitted it.
Makes sense. What about Crystal Crop's other points, the dye being an adjuvant, or those pith and marrow cases they cited?
The court didn't find those arguments convincing in this context. It acknowledged adjuvants help, but said novelty can still reside in such features if they solve a problem. As for the pith and marrow cases, the court distinguished them.
How so?
In those earlier cases, the elements left out were found by the court to be truly non-essential to the invention's main purpose or function. Here, Justice Bansal found the dye was tied to an essential function described in the patent, visual assessment. Without the dye, Safex's product might kill weeds similarly, but it didn't achieve that specific claimed result, visual assessment, in the same way. So it failed even the broader pith and marrow equivalence test in this specific aspect.
Okay, so pulling it all together, the analysis of the patent, the estoppel, what was the final decision on the interim injunction request?
Based on this analysis, the court's prima facie view was clear. The dyeing agent is an essential element of Crystal Crop's patented invention, as defined by Crystal Crop itself.
Right.
Since Safex's products admittedly lack this essential element, the court concluded that, for the purposes of this interim stage, infringement under the Doctrine of Equivalents was not made out. Safex's product didn't achieve the same result, including visual assessment, in substantially the same way.
And therefore the ruling was?
The court dismissed Crystal Crop's application for an interim injunction. No temporary stop order was granted.
Did the court mention the balance of convenience, like who gets hurt more by ruling one way or the other at this stage?
Yes, it did. The court found the balance favored the defendants, Safex. Stopping their sales now, based on this prima facie view, could cause them significant, potentially irreparable harm, losing market share, business disruption.
Whereas Crystal Crop could potentially get damages later if they win.
Exactly. The court noted that if Crystal Crop eventually prevails in the full trial, monetary damages could compensate them for losses incurred in the meantime.
But Safex still has to keep track of sales.
Correct. That's a standard practice. The court ordered them to maintain detailed accounts of sales for the products in question, so damages could be calculated down the line if needed.
Okay, let's tackle the so what. This is just an interim ruling. How significant is it really? Does it set a major precedent?
That's a crucial point. No, it doesn't set a binding precedent for other cases in the way a final judgment might. The judge was very careful to state that these findings are prima facie preliminary based only on the arguments and evidence presented so far for the injunction request.
So the court explicitly said this doesn't decide the final outcome.
Absolutely. The judge stated the observations have no bearing on the final outcome of the suit and the counterclaim. The main trial, where evidence will be examined in much greater depth, including the whole question of the patent's validity, is still to come.
So Crystal Crop hasn't lost the war, just this initial battle for a quick stop order.
Correct. They didn't get the immediate relief they wanted, but the case continues.
But even as an interim ruling, it's useful for understanding how these things work.
Immensely useful. For anyone interested in patent law in action, this case is a fantastic illustration. It shows how a court dissects a patent document looking at the background, the stated objectives, the detailed description, the claims to figure out the inventive concept. It demonstrates the doctrine of equivalents isn't just a free pass. It requires showing the variant works in substantially the same way to achieve the intended result, as revealed by the patent. And maybe most importantly,
The estoppel point.
yes, it's a stark reminder of the power of prosecution history estoppel. What you argue to get your patent can absolutely come back to define the scope of your rights when you try to enforce it. Consistency between prosecution and enforcement is critical. You can't easily dismiss features you previously highlighted as important.
So the big takeaway is really about how that seemingly tiny detail, a bit of color in a weed killer, became the absolute linchpin, at least at this stage. It wasn't just about the chemical formula. It was about how the inventor described its purpose and how they argued for the patent.
Precisely. It underscores that in patents, the words matter. The arguments matter. The entire history matters.
It really does make you think, doesn't it?
Yeah.
Beyond patents, just how might small details, maybe things you've said or positions you've taken in the past, shape outcomes later on in ways you didn't foresee? Makes you consider the fine print in everything.
It's definitely food for thought.